they're gonna want to come onto your property to inspect. Well, the very first thing is you're going to want to know where their jurisdictional authority is to come onto your property. After all, they're an agent of the federal government. They're not an agent of the state government, and there's a jurisdictional fence there. And if we begin to understand the difference between, and I probably should pull up the slides, but in most of the state constitutions, it says "we the people," and it is a small p, common noun. There are some anomalies. Tennessee is one of them. Virginia is not. It says "we the people," and you don't have a preamble in your state constitution. We do in ours, and it says "we the people," and it goes on and describes our Bill of Rights and other things in our state constitution. Now, the authority of the king devolved into the common people. That references the common people because it's a common noun. And you go to the federal constitution, it says "we the people," a capital P. That doesn't reference you and I. That references the agents of the state government. There were 13 original free and independent states that came into existence in the Treaty of Paris. Those 13 states sent their representatives, who are reflected in the language of "we the people," and they represent the state governments, created a government of the United States for a specific territory, which is 10 miles square, that resides in Washington, D.C. It is the military post and the needful buildings that are required to maintain all of that is their jurisdiction. Article 1, Section 8, Clause 17 and 18 says that the federal government has all authority to write rules and regulations for the people of the United States, and that's 10-mile square area. When Roberts wrote that the United States could force someone into buying something, he wasn't talking about the people that live in the Commonwealth or the people that live in the Republic, Alabama. He was talking about the people that live in Washington, D.C. He made a proper ruling. But since we don't understand the meaning of commas and colons and capitalization in legal documents, we think that it applies to us.
So Google Earth can only be used by the federal government? I mean,
Google Earth can be used by anybody that has access to the information.
But then so you're saying that the state can't utilize that and
This,
just go ahead and fine you based on Google Earth?
Well, the thing is that in Article 1, Section 9 of the Alabama Code, it says that the Code of Alabama shall not affect the right, remedy, or defense of the citizens of the state of Alabama. So we can write all the codes we want to, but if you have a right to private property, we can't affect that because your private property is a separate jurisdiction from that of the state. Remember, the authority of the king devolved into the people. We have that private jurisdiction. And the state, just like this says, the state doesn't have the authority to come into your jurisdiction and affect anything that you do, as long as it's a right. But now if we extend a privilege to you, that's a different story. And because the definition found in the first section of the Alabama Code defines property as personal or real, and we don't understand that our property is not personal or real, and we allow it to be defined as that, then we allow the code to be applied to our private property. And we need to begin to make the distinction again that property is private. Now, the best example of how to explain that, I think, is one Supreme Court case that was held in, or was presented in the 1960s. There was an individual that was being followed by the FBI, and he went into a phone booth in a mall, and he closed the door. As we all know, the young man here may not know what a phone booth is. Phone booths had glass walls in it. You could see through a phone booth. And the FBI wiretapped him and used the information in the case against him and won a conviction. He took it to the Supreme Court, and the Supreme Court ruled that he had a reasonable expectation of privacy when he closed the door, and therefore the agent of the government could not see into his jurisdiction. Now, let me, and I usually go through the slides, but since I'm here, let me talk about it a little more. In our system that was established April the 19th of 1775, which was by action of people, it was not something that anybody sat down and wrote about. It was later that the actions of people had to be reflected in the legal writings. Now, what occurred is that we placed Jesus in the place of the earthly king. The grantor was God the Father, and we are the beneficiary. Those rights are extended to us and are unalienable, meaning that the entity of government does not have the authority to place a lien against that which the Creator has granted to us. You disavow that and you're saying, I am no longer an American, because that is a concept published in the first document of the American people. It is not an opinion that I hold, and it is self-evident. In other words, I don't have to tell you, all you got to do is look around. This thing is created by someone that has a far greater reach than we can imagine. He is the architect of the universe, and he has bestowed each and every one of us with certain unalienable rights. If you go to the French Revolution and look up their rights, they are inalienable, inherent rights. And our system taught that the only thing inherent in man is a sinful and degenerate nature. Now, if you follow the inalienable right concept, you will find that the United Nations use it every time they talk about rights. It's inalienable. And those rights, by legal definition, are those rights which you can give away. I can't give away what the Creator has granted to me. Neither can I transfer that right. But I can transfer certain obligations to an entity called government and expect them to uphold that which the Creator has granted to me. Now, I can't see into the jurisdiction of God the Father. I can't even see His footstool. So the entity that we have created, as stated in that Supreme Court case, and as stated right there, the agent can't see into our jurisdiction because we are its creators. Now, as long as I don't affect the rights of any of the other people, and by the way, I'm not saying the code doesn't affect us, because if I violate the rights of another individual, that person has the perfect obligation and responsibility to go to our government and in an affidavit say, I have had my rights violated by my neighbor. I want you to look into this. I have a witness that has come forward, and here now is the law that he violated, the damage I suffered, and an unbiased witness. Look into it, government agent. Goes right back to Romans 13, verse 4, 5, or 6. And the government then has a responsibility to look into the tenets of this and determine whether or not there is validity in it, and then cause me to make the situation right. Now, that's the system we have, and we've got to begin to learn how to reassert that system so that it's no longer a commercial enterprise between us and them, and they're extracting fees and everything else from us.
Now, can you explain that when you say assert, that's a legal concept, latches and things like that?
Well, for instance, the comprehensive plan is a policy statement. And if we don't assert that it violates our rights extended to us from the Creator, it stands. And if, for instance, in adverse possession, the Supreme Court of Alabama says that if you possess a parcel, the rights to a parcel of land for 20 years, no one has the authority to come and rebut or object to those title to that property. So in this case, if we allow a comprehensive plan which obviously incorporates sustainable development and violates the rights granted to us by the Creator, after a period of time, let the dog lie, is the saying. And we have no authority to come and rebut or object to what has been on the books for a long time.